My lords and my lady, I appear for the appellant in this matter with my learned junior, Mr. Mackenzie. Ms. Giovanetti, King's Counsel, Mr. Deacon, Ms. Thielen appear for the Secretary of State in this matter. My lords and my lady, I propose to deal with matters probably fairly obviously in this order. Firstly, whether or not the issue of whether or not there's a power to award costs. Secondly, on the assumption there's a power, what principles should be applied. Thirdly, on the assumption unreasonable conduct is required, whether SIAC was entitled to find that the Secretary of State had not acted unreasonably. Before doing that, I think though I should note there's one sort of preliminary matter, which is why there's a reference to an application. And that's the status of Article 14. We would argue that the grant of leave effectively covered Article 14. The reason for that being that
well, don't for the moment. All right.
So,
no need to argue the point.
Thank you.
Now, we've obviously discussed this. We may as well tell you that our provisional view, from which you may well dissuade us, is that you need permission.
Yes.
And it seems to us that the sensible thing would be to postpone consideration of that until we've heard argument from both sides on the non-Article 14 issues. At the end of it, we will hear your application for permission to amend. In practice, if you get permission to amend, you'll also get permission to appeal.
Yep.
On that point. Well, obviously you will, sorry. And then if we decide to give you that, we'll then hear the Article 14 issues. It seems to us they're reasonably self-contained.
Okay. My lord, I'm certainly happy to deal with it in that way.
You're happy as well, Ms. Giovanetti?
Absolutely, yes, thank you.
What I might do though, before so it doesn't confuse me when I get to it, is remove my notes on Article 14
yes, by all means,
now.
Sort out.
So that I don't get confused when I get to it. Well, then, parking for the moment, then the Article 14 issue. First question, obviously, I identified a moment ago, is what is SIAC's jurisdiction essentially as a matter of domestic law? And I think in relation to that, the parties do seem basically agreed that obviously the starting point is the SIAC Act. And you have in the authorities bundle, if you're using the hard copy, it's volume 2 of the authorities bundle, tab 45, page 1, 2, 3, 4.
And if you're not using the... Well,
it's still, then it's just page 1, 2, 3, 4, my lord.
thank you very much.
Couldn't matter less. The bundles are beautifully put together, but my only tiny complaint, I think it's a complaint against Doughty Street, is if you've got two bundles, can one of them be marked 1 and one of them be marked 2? But, however.
I'm sure my learned junior will pass that back, and yes.
But they are very well put together, genuinely. So, bouquet as well as brickbat.
Yes.
Yeah, okay.
As I say, tab 45, section 1. I'm not that we
well, sorry, I might have to take this back. If it's tab 45.
Yes. If I've noted it, that may be.
No, that's correct. But you gave a different page number.
Well, you may get a different page number early on because I think what's happened, and I don't think it particularly assists. I've gone to 1, 2, 3, 4 because that is the current version. I don't think we've got, for reasons.
Actually, well, look, let's not worry.
Yeah.
I just thought tab 45, which you gave, is not 1, 2, 3, 4. It's 1, 2, 2, 6.
Yeah, sorry, I was going to 1, 2, 3, 4 within that tab.
Yes, I see. Okay, fine. No, then now I understand.
Yes, sorry, I should make that clear. When I give page numbers, I'll generally be talking about.
Yes, I'm sorry.
No, that's not. That is the current version of section 1. As I say, I'm not sure that anything very much turns on the historic sort of iterations of it. The critical point, obviously, being that section 1, subsection 3 provides, which is not an uncommon provision, that the Commission shall be a superior court of record. And in one sense, that may well be, well, certainly is a key issue, what essentially flows from that status. We submit that obviously it is intended to have some significance, and it in particular has a significance in relation to the powers that SIAC enjoys. The Secretary of State suggests it was unsuccessfully an attempt to insulate SIAC from judicial review. In one sense,
Well, it could be both, couldn't it?
Well, it could be both, yes.
I'm speaking for myself, I'm convinced at the moment that that's probably why it was put in, but that doesn't mean that it doesn't also have the effects that you contend for.
Exactly, my Lord. It clearly, we would submit it's clear, not least because it can't, that it has other effects, essentially. The appeal in this case was brought under Section 2B of the SIAC Act, which is 2 pages further on, 1236. And that essentially just provides that there is a right of appeal. That links back, the lady asked for copies of Section 40A, which have been provided. Again, in one sense, it says nothing about what the powers of SIAC are on an appeal. And to that extent, it contrasts with some of the provisions governing SIAC jurisdiction. If one goes to Section 2C, which is at 1237, that provides that the Commission applies the principles in judicial review. That's in a review of exclusion decisions. There's a similar provision at 2D, but I'm not sure anything really turns on the difference, and indeed 2E. That is in our submission in 2C, a provision which is intended to limit the powers of SIAC, but by making it clear that what is in issue in a 2C case is a review, not an appeal. Now that's maybe of some significance because it certainly has been suggested, and we've identified an example of this being applied, that SIAC has jurisdiction to award costs in a 2C case because of the reference to judicial review. In our submission, it would be slightly odd if SIAC has a power to award costs as a result of Section 2C3, a provision which, as we've already indicated in our submission, is intended to limit the approaches.
Well, it's not just 2C3, is it, Mr. Sullivan? It's also 2C4. If the Commission decides the direction should be set aside, it may make any such order or give any such relief. It may be made or given in judicial review proceedings. Isn't that the point?
Well, that's, yes, sorry, you're right, my lady, it is 2C4 as well. My point, though, still remains, which is that what this, on the face of it, is intended to do in our submission is narrow the jurisdiction of SIAC by limiting it effectively to a JR approach. And it is somewhat odd if through that sort of side door, or through that narrowing approach, the cost jurisdiction is then introduced.
Well, it's not narrowing SIAC's powers because before 2C was brought into force, SIAC had no power to do anything with exclusion decisions.
Well, it's narrowing in this sense. It's clearly 2C.
Well, surely, basically, perhaps you shouldn't say narrowing, suggests it was something different before. It's defining the power in a narrower way than it might otherwise have been.
That's a better way of putting it, my lord. Yes, that's a better way of putting it. Section 5, which is tab 47, page 1255, is the current iteration again, is the power to make rules. And subsection 2A permits rules to be made to do anything which may be done by tribunal procedure rules. Now, this may be a bit of a red herring or a sidetrack, but I think I want to make our position clear in relation to that. The tribunal procedure rules clearly can include provision as to costs. However, in our submission, the origin essentially of the power to award costs in the upper tribunal is not the power to make rules. What the rules in the tribunal can do is prescribe the approach to the award of costs, not, they don't permit, or they don't require, perhaps is a better way of putting it, the tribunal to, they can't require the tribunal to award costs in circumstances where they would be otherwise unable to award costs.
I think you'll have to.
So it's about the exercise, effectively, of a power, not the granting of a power. That would be one way of putting it.
But
But
in any event, the power is granted by, I can't remember, one of the sections in the 2007 Act. Is it section 22? I think it's one of the things that's not in the bundle.
Sorry, you mean the Tribunal and Courts Act?
Yeah.
Yes, absolutely. Well, my lady, we would say it records the existence of the power, but we'll come on to that. My point here is that there is and I don't want to get sidetracked, but there is an issue raised by the Secretary of State as to whether in SIAC the power in section 5.2a could be used to grant a power to award costs. And our point is that it can't be, because the tribunal procedural rules can't give rise to a power if there weren't one already.
No, but isn't that analogous? Just go first to the tribunal procedure rules. We've now got section 22 or whatever it is, but there is, I think it's common ground, somewhere in the TCEA, a power to make rules about costs.
About costs, yes.
And then the rules, which is actually referred to here,
yep,
are made pursuant to that power. But why is 5.5 not the equivalent of section 22? If you spell, it would simply be saying there is a power to make rules about various things, and rather than spell out what all the various things are, they are the things covered by the tribunal procedure rules. So section 5 and section 22 are doing the same job.
Well,
and it might be a little bit easier, but this may be a bad point, so let me just check before I put it to you.
But 5.2a, doesn't 5.2a do the same thing? It's very straightforward. Rules under this section may in particular do anything which may be done by tribunal procedure rules.
Sorry, if I said 5.5a, I meant 5.2a.
Oh, I'm so sorry.
No, well, I don't think it's what I said. So I was just looking back to see whether it looked any different in the original version, which is 5.2a on page 1243. I'm not sure you can, I don't think that really raises any separate point. It just happens to be a different statute. But the real point I'm putting to you, Mr. Southey, is that what 5.2a does is confer a power to make rules about various things, including costs. And therefore, it does just the same thing as section 22 of the TCEA and the whatever the rule is in the Employment Appeal Tribunal and so on.
Well, and this, I mean, it may come down to some of our other arguments in one sense, but the point I'm making is there is no dispute, and so the power to make tribunal procedure rules includes a power to make rules that essentially establish the principles to be applied when awarding costs. So, I mean, for example, the tribunal rules can, as they do say, that costs are only awarded if a party's behaviour is unreasonable. That's about the practice of exercising the power.
Yeah.
Our point is that the origin of the power is not the rules. And
no,
so
but isn't the origin of the power the provision in the primary statute that says you can make rules about costs?
But there's a separate provision, isn't there, that just gives the upper tribunal power to make costs.
Exactly. I'm going to come to that and what we say about that. But my point about that is the point. In fact, my lady has just put to me that there is a separate origin. I use that word deliberately because obviously there is a dispute about precisely what the origin is. But there is a separate origin of the power to award costs other than the rules. On either party's case about what
You
happens,
mean other than the power to make rules?
other than the power to make rules, yes. On either party's case, whether it's the appellant's case or the Secretary of State's case, the reason the upper tribunal, for example, and indeed the first tier tribunal, can award costs is not because there are rules providing for the award of costs. In the Secretary of State's case, it is because the legislation expressly provides for it. In the appellant's case, it is because that power arises from the tribunal status as a court of record, and the primary legislation in separate provisions recognises that power. We'll come on to which of those is correct. But either argument means that the origin of the power is not the rules. The rules govern.
I think everyone would accept that. I think you're straying to an open door, aren't you? The real question is the one you just said you want to come on to.
Well, but the reason I'm making this point now.
Just sorry, before you go on to that, Mr. Southey, I mean, isn't one possible explanation for the difference that the tribunal rules are not made by the Secretary of State, they're made by the Rules Committee?
Yes. But sorry. Yes, but I'm not, in one sense, not sure where that takes us, because, as I say, in terms of the point I'm making, and this may be a red herring. I'm not sure in one sense where this takes us, but there is a disagreement between the parties in one sense about whether Section 5.2a could be used to establish a power to award costs. Our point is it can't, because the tribunal procedure rules, the relevant provision in the 2007 Act, isn't about establishing a power to award costs. It's how an existing power can be exercised.
Well, perhaps we'll have to look at that in a moment. But not every statute uses the same drafting technique.
Yeah.
Can I just ask you a question? Did you say that the FTT's power towards costs was because it was a superior court of record?
No, not the FTT. The FTT.
No, but I think your submission was that the distinction between you and the respondent was that the different starting points, and you said the UT and FTT both had theirs as an inherent power because they were superior courts.
If I did say that, that was me misspeaking. Our position is about the upper tribunal.
So where does the FTT get its jurisdiction from on your analysis?
That is statutory because it is not defined as being a court of record. You have to accept that.
So, and what is the distinction between it being statutory for the FTT and the upper tribunal? Well,
the distinction is, as I've already indicated, is that for the upper tribunal is defined as being a court of record, and that brings with it, we would say, the necessary, as an implication, the power to award costs.
Speaking for myself, I think if we're going to, unless you want to come back to it later for some other reason, if we're going to have this argument now, we need to look at the provisions of the 2007 Act, though subject to the big caveat that even if the draftsman's done it slightly differently there, it doesn't necessarily mean that the draftsman of the 1997 Act had to proceed in the same way.
I'm going to come, if I may,
Okay.
I'm going to come back to the 2000,
Well, we'll
because
stop
in one
asking
sense I
about
think
it then,
it's
you're coming back to it.
all I was doing really was putting down, what I was trying to do, and it was, as I say, put down in one sense a marker about the...
It always happens when an advocate puts down markers. The court starts to have into the argument then. But okay, well,
I mean, the way I wanted to deal with it, and I hope this is of assistance, is to look first at the relatively limited learning we've been able to find about what court of record means.
okay. Well, then let's we'll try and restrain ourselves.
Okay.
But don't put down too many markers, as we may not be able to resist the temptation.
Can I come then to CART, which in our submission is obviously certainly this is in our submission. This is probably the key authority because it is where the greatest the only real consideration has been given to what this phrase "court of record" means. And if one goes to volume 1, tab 24, and the relevant passage starts at 656 in the judgment of Justice Laws. Paragraph 8. Paragraph 8 just demonstrates, the reason I just take you to that is that because what was an issue was whether or not it was possible to judicially review SIAC, among other bodies, the provision of section 1 was directly an issue, and in particular the provision that provided it that SIAC was a court of record. Obviously, to some extent, this is consistent with the impression that the idea of being a court of record was to insulate SIAC from judicial review, because that's how it was deployed in CART. CART obviously also went on appeal, but in terms of this issue, I'm not sure there was any further consideration of it, because
There isn't, but what Lord Justice Law says is expressly approved by Lord Justice Sedley.
Lord Justice Laws at para 54 notes that effectively there are 3 distinctions that can be found in the authorities that are potentially relevant. The first of those is about effectively presumption as to jurisdiction, and I emphasise that because although Lord Justice Laws also makes the point at the end of paragraph 54 that the distinctions are not hermetically sealed, he in paragraph 55 makes it, and then paragraph 56 makes it clear, to use his language in paragraph 56, that the balance of authority favours the claimant's argument, which, as you see from paragraph 55, was that essentially Superior Court of Record was a description of the first distinction.
Can I just ask, he perfectly understandably and sensibly just shortens it to Superior Court and Inferior Court. What does the of record add?
Well, there is, I think it's fair to say, if I remember rightly, later on, an indication that of record may be of relevance because of the precedent value, effectively, of judgments.
I'm not a legal historian. That doesn't sound to me a very convincing explanation.
It was also particularly important in terms of what notes were made of the evidence, and whether you could rely, therefore, on transcripts and notes, or whether you had to have separate evidence of what was said.
That may be right. The reason I was...
well, I don't want to slow this down. If there is, and I obviously read this, I didn't see that particular point dealt with, and it strongly suggested, therefore, that it doesn't actually add anything to the debate. But if those behind you or those behind Ms. Giovanetti know the answer and can tell us at some convenient point, that would at any rate satisfy my.
I think I could give you the answer. The reason I was making reference to precedent, and it links in fact to the point that was put to me by my Lord Justice Dingemans, is at para 75 there is reference to precedent, which, as my Lord has pointed out to me, was because of the record it keeps. And so, in one sense, I was looking at the consequences of the record, but my Lord is right about the records as well.
Oh, I see. I had, although it was sidelined, I hadn't twigged that the reference at D to that's no doubt the record it keeps.
Yes.
Yes, sorry, but I'd missed that, and that is a complete answer. Thank you very much. Right, go back to where you were.
So, my Lord, yes. So, the first distinction essentially is having indicated certainly Lord Justice Laws's conclusion that the first distinction is the most important. He then deals with that essentially by or describes it by citing firstly at paragraph 57 Hallsbury and the passage of Hallsbury he cites, which I think we've indicated in our skeleton as far as we've been able to find remains cited unsurprisingly in Hallsbury's or remains within the latest edition of Hallsbury. It is essentially one which is about jurisdiction. It's about a presumption of jurisdiction. And he then again, sort of consistent with that, cites an authority about ecclesiastical courts, ex parte White, paragraph 58. The last sentence of the citation, the first passage of citation from that judgment, again, talks about presumption to the presumption.
We can take this quite short, as you say, that is what the first distinction is, and it's very fully stated in Hallsbury.
Yeah, exactly. And that's important in our submission. That doesn't mean, and we've never sought to suggest this, that effectively SIAC, for example, is a court of unlimited jurisdiction, because clearly the reason SIAC, for example, couldn't deal with a housing case is provisions such as Section 2B determine effectively what cases it can determine. But what it does in our submission indicate is that once SIAC, as it undoubtedly had in this case, has a case before it, which comes within a provision such as Section 2B, the presumption is that it has powers necessary to deal with that case. Now, it's true, as my learned friend points to, that if one goes to paragraph 77, 676, four lines into paragraph 77, Lord Justice Laws says, nevertheless, like SIAC, it, meaning the upper tribunal, owns only the jurisdiction given to it by statute. And as I've already indicated, it's quite clear from the statutory scheme that the statute, the SIAC Act, by, for example, including provisions such as Section 2B, is intending to make it clear that SIAC can only deal with certain categories of case. But that doesn't, in one sense, answer the questions that arise as a result of this case, because you have those provisions which make it clear, as I say, that SIAC can't, for example, deal with a housing case, but they are in the context of Section 1, which makes it clear that SIAC is a superior court of record. And in our submission, the way in which you sort of fit those two provisions together is to recognise that SIAC can only deal with the cases allocated to it essentially by provisions such as Section 2B. But when dealing with those cases, the presumption is SIAC has whatever jurisdiction it needs to determine the case.
Do you mean jurisdiction or do you mean powers?
Powers, sorry, powers.
How does that broad statement fit with the rather detailed provisions in Section 5 about what the Lord Chancellor can provide for in rules?
Well, in our submission, the powers are, well, there are two ways that fits together. Firstly, if you didn't have a provision such as Section 5, and this is why Section 5 is potentially of greatest importance, it would be open to SIAC to develop a procedural code using its inherent powers, as we would describe them, but that would be limited by the fact that one of the restrictions, CL Rawi, that I'll come to, is that those inherent powers can't be used to deprive someone of fundamental rights. And particularly in the context of SIAC, of course, by departing from a normal aspect of fair procedure, the right to see the case against you, it is necessary for there to be a rule-making power that permits that departure, for example, and it's clear that it does, and that's this Court of Appeal authority that makes it clear that that's that the rule-making power extends to depriving a party of their normal common law rights to a fair. So that's the first reason. But secondly, in any event, the fact that, and this is sort of going beyond the SIAC context, the fact that there is a starting point of a broad power to regulate one's own procedure or determine one's own, the procedure that the court should adopt, doesn't mean that a rule-making power isn't of value, because, and this goes to a case that I'm going to come to about costs, the aid and shipping case. It could be of value to give someone, effectively, to recognise someone's got broad powers, but then enable rules to be set so that there's consistency, so that there's clarity as to the way in which a procedure should be adopted. And so it effectively enables rules to be adopted that narrow what would otherwise be a broad discretion. So one looks at the approach that SIAC adopted in this case, in the cost judgment. I won't take you to it, paragraph 13A, which was to say, as a creature of statute, SIAC has no inherent jurisdiction. And our submission, that is wrong, essentially. The starting point is that because it's partly because it is a superior court of record, it does have an inherent jurisdiction. The question really is what the limitations are on that. And I mean, I'm going to come to the two articles, the article by Sir Jack Jacob and the article by Professor Dockeray, both of which have been cited at times by courts about inherent jurisdictions. But even if one takes the narrow approach of Professor Dockeray, which is clearly narrower than Sir Jack Jacob's approach, he recognises that there are inherent powers. Where he disagrees with Sir Jack Jacob is effectively where Sir Jack Jacob says this is some sort of reserved general power that allows you to do justice. He says that's wrong. What's actually happened is there's been
The question about inherent powers sort of overlaps with the question of superior court of record, but they're completely different. the same. One derives from a particular rule of legal history about powers of a superior court. The other says that any court must have ancillary powers to enable it to do the things which it's required to do, whether those arise at common law or by statute. There's plenty of jurisdiction, for example, that purely statutory tribunals, which aren't superior courts of record, have inherent jurisdictions as well.
My Lord, I don't disagree with that, but at the same time, I wouldn't accept they're totally. I mean, the reason I made reference to it in one sense is I wouldn't accept that they are totally sort of separate concepts, in the sense that if you start,
I didn't really mean to say that they were.
I don't think you did, my Lord. So yeah, sorry for interrupting. But the reason I was saying that there's an overlap in one sense is this in the sense that. If you start from the presumption described in Hallsbury's in our submission that there is jurisdiction, wide jurisdiction essentially for us at the Superior Court of Record, particularly in circumstances where that phrase has to have, or that approach has to have some meaning in a body like SIAC that is statutory. Indeed, that's the context in which Lord Justice Laws was applying it. One of the ways in our submission that potentially applies is in your approach to inherent powers. And one could look at it like this. If you're in the Superior Court of Record category of tribunals, then the inherent powers that have been identified, whatever those are, and I'll come on to those, essentially apply, because prima facie they are something that the court has jurisdiction to exercise, unless they are expressly or implicitly excluded. In the inferior tribunal context, in one sense the burden is the other way round. Those inherent powers may be necessary, but the individual essentially has to demonstrate why they are necessary to achieve the statutory aims of the inferior court.
Yeah, okay, thank you. I see how you put it.
Yeah. So that's in one sense the starting point, and I'm not sure there's any greater learning on that, but it raises the question, as I've already indicated, what are the inherent powers in relation to costs? We've identified a couple of lines of authority indicating that those inherent powers at least can include the power to award costs. The first authority we've identified is which is at tab 7 of the first volume of authorities, page 207, Guardians of West Ham Union, which is, I mean, 207 is the relevant passage. It is a case wherein a Chancery appeal, if I remember rightly, the House of Lords decided it had inherent powers. It's the judgment of Lord Macnaghten, page 207, halfway down the page, the paragraph that starts another point. Going over the page to 208, where he makes it clear, 6 lines into 208, that it is an inherent jurisdiction Now, a couple of points about that. The first point I think made against me is that there is a lack of full reasoning in that judgment, but on the face of it, it is still a decision of the House of Lords that, to some extent, probably reflected practice at the time. More significantly, possibly, it said against me that this passage doesn't suggest there is never a need for statutory authority. But the point we would make in relation to that is if, as is clear, this is a conclusion that inherent jurisdiction does extend to the power to award costs, the question then arises is why should the House of Lords essentially be in a different position to other superior courts of record? Is there any basis essentially for concluding that the House of Lords, as it then was, and indeed the Supreme Court now, have wider inherent powers than any other court? In our submission, there isn't any basis for that. None of the materials cited, as far as I'm aware, certainly none of the academic material draw a distinction between different superior courts, and indeed, when we come to the article by Professor Dockeray that I've made reference to, he expressly makes reference to the fact that historically courts have awarded costs on the basis of inherent powers.
Can I just ask you whilst on this passage? At this time, the House of Lords had no statutory jurisdiction to award costs, is that right?
That's right, that's clear.
Because otherwise they'd have referred to it.
Yes.
Now, if you're right that implicit in saying superior court of record, you magic up these chancery powers which were converted to common law powers, it seems, if you read the authority.
Yep.
How does that withstand legislating in that area? So that if there hadn't been a statute that gave you a right to make rules about costs, then one might have understood that point. But of course we've moved on, as indeed has the Supreme Court, because we have the Senior Courts Act.
Well, that in one sense comes back to the submissions we've made about the language of those provisions. Our point, our position is fundamentally that what those provisions assume is that there was a jurisdiction to award costs, and they're primarily about how you exercise that jurisdiction. They are not they are phrased in a slightly odd way if they were intended to grant a jurisdiction where Parliament believed there was no jurisdiction. I'll come on to that, but it's probably easy to deal with that when we come to the legislation. One point, though, I should make, which we make in one sense, we do make in our skeleton argument, but it may not. It's not in one sense the highest profile point in our skeleton argument, and I recognise it doesn't necessarily take us that far. Is that, of course, my Lord makes the point about statutes. The Constitutional Reform Act, as far as we can see, doesn't include an express provision about costs. It refers to the Supreme Court being a superior court of record. But clearly practice is that costs, and indeed that's provided for in the rules, costs are awarded.
If you go back to the West Ham Union case, Lord Herschel's approach is quite straightforward. Page 202, towards the foot of the page, he says costs have been awarded in such appeals for upwards of 2 centuries. I see no other foundation on which the power to order their payment can be rested, except the inherent authority of this House as the ultimate court of appeal.
But my point is, and that's not inconsistent with the passage in my submission that I drew attention to, is this is a recognition in our submission that courts, the inherent power maybe because it dates back several centuries, but the inherent power has been, the inherent powers of courts has been held to at least extend to this particular jurisdiction, which was the common law, which was Chancery appeals in the House of Lords, and that once one gets to that starting point, the question
and not just Chancery appeals. I think you ought to read the next sentence.
Sorry,
yes, it's a QB case.
Yes, no, sorry. Yes, that's right. And indeed, in fact, I think in fact, Lord McNaughton, in the passage I drew attention to as well, references other jurisdictions. But my point is, my fundamental point about this is well, at the risk of repeating myself, once there is a recognition that there is an inherent, that in certain circumstances there is an inherent power to award costs, is there any basis then for saying that is not something that is generally enjoyed by courts? And in my submission, there isn't any basis for that, because inherent powers...
But the reasoning in both judgments is tied to the fact that this is the highest court, its inherent authority is the ultimate court of appeals. That's Lord Hirsch on page 483 and Lord McNaughton on page 489.
Absolutely, but
I don't see how that reasoning can just be generally extended to other courts.
Well, two answers to it. The first is that fundamentally we would submit that the inherent powers don't depend on the court in issue, save that there is this distinction between superior courts and inferior courts. But secondly, of course, we rely on the second line of authorities, which was that noted in ex parte Osman, which was the power to award costs essentially in the divisional court, practice of awarding costs in the divisional court.
Are you going to take us to that now?
Yes. We go to 445, it's tab 14 in volume 1, 445. It was actually probably important to start at 444. And the issue in that case was, because of the nature of the statute, what was the practice essentially before the 1981 Act? So the issue wasn't directly inherent powers, but it was indirectly inherent powers, because it was inherent powers that were relied on.
Because Lord Justice Lloyd, quite early on in his judgment, refers to Section 51.
Yes, exactly. Because
being the jurisdiction to all costs in the present case.
Yes, but he because there was a sort of carve out which depended on earlier practice, it was necessary to consider what earlier practice was.
Yeah.
And that's the context. And I should say, the bundle includes a number of the earlier authorities, but I don't think any of them, as far as I can see, assist greatly, because they're just cases where the court just orders costs, and all one gets from the reports is an order for costs. So Lord Justice Lloyd, from, as I say, probably 2/3 of the way down, where on page 444, the paragraph starting, then comes the question, reviews practice before the 1981 Act, section 51, and refers to essentially two lines of authorities. First, specific cases to do with the divisional court, and then secondly, in fact, the West Ham Union case. and it concludes essentially on 445, second paragraph at the page, that the practice essentially was to award costs in those cases. Now, it is fair to say, if one goes to 446, by the top hole punch, second full paragraph, the paragraph starting next Mr. Ross Munro, that Lord Justice Lloyd leaves open the question essentially as to whether...
But then this doesn't really get us anywhere, does it?
No.
Well,
How does it help?
It helps us to this extent. What it records is the practice of the divisional court was to exercise essentially a cost jurisdiction without, in habeas cases, without there being any statutory authority. Now, the judges involved were two former Lord Chief Justices, and so that, in our submission, has to carry a degree of weight. And it links back in our submission to the West Ham Union, the point I was making about West Ham Union, which is, if there is an inherent power, it is difficult to see why superior courts should be treated differently depending on which superior court they were. I'm going to come on in a moment to the materials about inherent powers generally, and in our submission they don't provide any distinction for any basis rather for distinguishing between different types of court, and this is an example of that in the sense that admittedly in circumstances where the basis for these awards of costs were not fully reasoned, the reality is that senior judges have concluded the court is able to award costs without statutory authority. Well, that's why we rely on them.
Yeah. Where are we going now?
Can we then go on? As far as the specific issue of costs, that is, I mean, that's the limit of the authorities. I think either party has been able to identify, whatever one makes of those authorities. There are, though, obviously a series of cases looking at inherent powers generally, and taking you through those reasonably, hopefully reasonably efficiently. The first one authority that we draw attention to is Connolly versus the DPP, which is in volume 1, tab 9, relevant passage, page 266. There, Lord Morris stated as a matter of principle, essentially, that effectively that a court is endowed with a particular jurisdiction, that the particular jurisdiction has powers which are necessary to enable it to act effectively within such jurisdiction. And in our submission, if one adopts that approach.
Sorry, I'm just reading the head note to try and situate the statement in some kind of factual context.
Presumably the power to dismiss a charge for
That's right.
prosecution for ultra quid.
Yes. Yes, I think that's right, Lord. The point that I was going to make is that if one adopts that approach, effectively the approach described by Lord Morris, then in our submission it is not terribly surprising, essentially, that a power to award costs has been identified as being an inherent power, or has been applied by courts as an inherent power, because clearly costs can be, in our submission, necessary to ensure that litigation is effective, to ensure that a party, for example, with a valid claim is not discouraged from bringing it by the costs of bringing it. So that's, in our submission, an important starting point, because if what one then sees in perhaps slightly more modern cases dealing with inherent powers is a distinction drawn between procedures and substance. So one then goes to tab 15, page 452. And this just one sense, the complete, I just happen to be sort of flicking through it to get there, and it goes back to the question I think my Lord Vice President asked me about the relationship between Superior Court of Record and inherent jurisdiction. Just in passing, worth noting perhaps according to the head note, the final holding essentially is that you can make directions regulating procedure, providing such direction was not inconsistent with the rules of the court. And so it links back to the point I was making, which is that our submission fundamentally is that the court has broad powers unless, and that's why in one sense you need the power to make rules, because by making rules you can then, it is possible to restrict those powers. I think it was in question, it was in response to a question from my lady I made that point. But the passage I was going to take you to at page 452 by letter D you see probably the uncontroversial statement that every court has inherent jurisdiction to regulate its own procedures, save insofar as such direction is inconsistent with statute law or statutory rules of court. And that, in our submission, is of relevance because fundamentally, and I recognise the dangers in this, and I think it's, if I remember rightly, it's Lord Dyson in Al Rawi who makes the point that determining what's substantive and what's procedural can be difficult. But we would submit, certainly, that costs ultimately are procedural. They're not freestanding litigation. They exist, essentially, to ensure justice between the parties.
Might that depend on what the court is doing and its jurisdiction? In SIAC, it was set up to avoid the situation where it was all declared non-justiciable because it involved matters of national security. There was then set up a very sophisticated system for special advocates, etc., paid for by the state. And the appellants there are provided for exceptional funding under legal aid regulations because they have to have liaison with special advocates. Is that right?
Well, my Lord, there's a couple of things I should unpick in that. The first point in my submission is that it's important potentially to distinguish between whether there's a power to award costs and how that power should be exercised. So my Lord put to me a number of features of the SIAC regime. Our position would remain that unless it's expressly excluded or by necessary implication, the power exists. Now, whether that power should be exercised may need to take account of the special features of the SIAC regime. I'd obviously potentially point to some other factors that might weigh in the other direction, but it is important in our submission to draw that distinction, because none of the factors that my Lord has drawn attention to in my submission none of them expressly exclude the power to make costs, and none of them by necessary implication prevent the award of costs. I mean, closed procedures do result on occasion in an award of costs. High Court closed procedures, for example, result in an award of costs. One final point I should make is my Lord may...
Sorry, Mr. Southey, just to be clear about your response to my Lord Justice Dingemans' question, you're not taking issue with any of the features to which he's drawn attention, are you?
Well, there is one. I'm just going to take draw attention to it, which is I think I hope I haven't missed any others, but there is one, and that is the legal aid position, in the sense that the legal aid position is not automatic in SIAC. There is no automatic legal aid. I mean, my client is legally aided, but Goulet in the Supreme Court makes it clear that shouldn't influence the approach to costs.
So in outline, what are the criteria that are taken into account in deciding whether or not an appellant in SIAC is legal aid?
The major one is means.
So there is a means test?
There is a means test, yes. Right. So I'm aware of cases before SIAC. They're not common, I accept that, but I'm aware of cases before SIAC that have been privately funded. I've appeared in one.
Yeah, I expect the SADs were privately represented.
Yes. Well, I represented a very wealthy entrepreneur. Right. So that factor in particular, I think I would submit one has to be very careful about, because whatever approach this court adopts will apply to privately funded, and that's why we made reference to the Goulet case, which makes it clear, perhaps unsurprisingly, that as a result legal aid should be discounted.
Yes, but that's dealing with a slightly different question. It's not saying legal aid is irrelevant to whether the power to award costs exists. It says legal aid is irrelevant to the exercise of the discretion to award costs, I think. Yes, I think it talks about the principles to be awarded, but the point I'm at, in one sense, it's still, we would submit that the approach to that is fundamentally an indication that the existence of legal aid doesn't necessarily mean that there isn't an importance in being able to award costs. One can't assume. Fundamentally, this is a question of statutory interpretation.
Exactly.
Yeah.
And just to be clear about this, your essential point is that a costs jurisdiction is a necessary part of the jurisdiction of a court or tribunal, unless excluded, as inherent. Essentially for two reasons. Parties may not be able to get justice if they have to pay lawyers without knowing they'll get the money back if they win.
Yes.
There's another element also. Just thinking this through, is maybe a bad point, that impecunious parties may be deterred from seeking justice if they have to pay the costs if they lose. That's really a point of a different character, isn't it? Well, they will sometimes be protected by legal aid, but not always automatically.
But my Lord, also, the other point is that in one sense that potentially goes to practice, in the sense that there has been, when sort of researching for our skeleton, I couldn't find this in writing, but certainly in the High Court level, my experience has been, at the risk of giving evidence, that where there's a closed procedure, judges have generally been unwilling to apply effectively what might be described as an even-handed approach to the parties. They've been more willing to order costs against the Secretary of State than in favour of the Secretary of State, because they accept the point that an individual who brings closed procedures isn't in as good a position as the Secretary of State to assess merits. Now, whether that's right or wrong is ultimately a matter of practice, and there may be arguments about that. But all of that goes to practice. I mean, clearly, if I'm right, that effectively the basis of any inherent power to award costs is the potential need to do justice between the parties, then in practice, how those cost rules are applied will need to reflect what is necessary to do justice.
Yes, thank you. I think my point was probably a red herring, but it was just helpful for me to expose it.
So on your submission, you don't even need it being a court of record, because you say it's necessary to do justice anyway, which any court or tribunal has jurisdiction to unless it's excluded.
Well, the difference, the reason why we start from the court of record in one sense is just because, I don't disagree with that, it should start by saying, but the reason why we start from it is, in one sense, it's easier from our point of view, because it means that you're looking to see whether there's something that excludes that starting point, rather than looking for whether it's that starting point of there being...
That's back to the exchange that I had a little while ago.
Well, Lord, the approach that I've just drawn attention to, the Langley approach of focusing essentially on, when looking at what the inherent powers of a court are, focusing on procedure, is then followed in the sort of subsequent cases that the parties between them have cited. If one goes to Wicks and Wicks 473...
So just going back to what was actually at issue in Langley, that was whether or not a county court had power to issue a local practice direction.
Yes.
Is that it?
Yes.
So it's a fairly vanilla procedural sort of thing.
Yes.
That's not very articulate, anyway. All right.
No, but and I recognise. I mean, I think I mentioned there's certainly commentary. I think it may also be Lord Dyson in Al Rawi, which I'm going to come to, which makes the point that drawing the distinction between what is procedural and what is substantive is not always easy.
All right.
But obviously, in relation to practice directions, that is relatively easy.
Yeah.
The next authority that I probably ought to just touch on is at page 473 of the authorities bundle, tab 16, still in volume 1. Wicks and Wicks. Looking at effectively the circumstances in which there was a power to order the sale of a matrimonial home. And at the bottom of page 473, Justice Ward firstly made it clear, and this isn't our case, I should make it clear that we don't need to go as far as he was describing, that, to use his language, there's powerful authority for rejecting the contention that inherent jurisdiction confers a general residual discretion necessary to do justice to the parties. But what he then goes on to do, which is why I draw attention to it in this context, is if one goes to letter B at 474, starting, there's a 2 sort of in the middle of the paragraph, he distinguishes between a procedural right and a substantive right. And what he concludes was in issue in that case, which, as I say, was about sale of the matrimonial home, was about a substantive power. And he then cites 2 authorities, essentially, that draw that distinction and concludes by letter E by making it clear that, citing a judgment of Sir John Pennycook, making it clear that there's a broad power again to regulate procedure.
How does this case help your argument?
Well, it goes back to the point I made earlier. We would certainly argue that what's in issue in a cost context is procedural for the reasons I indicated. Or the jurisdiction to make costs is procedural because it is about the regulation of existing litigation. And that explains why, in our submission, in the examples we gave, the West Ham Union case and the divisional court cases, inherent powers have been held to exist because they are ultimately about power to award costs is about regulating procedure, or about regulating the litigation, and that means it's procedural. That's followed, and I'm not sure, looking at it and thinking about the time, we get that much more because it makes it the same distinction. The other thing it does is cite the Sir Jack Jacob paper with authority.
What are you talking about?
I'm just going to mention the next authority in line, which is
what?
Taylor and Lawrence at tab 17.
Yeah, I see.
But I'm not going to, I'm thinking about time and whatever, I'm not sure it makes sense to go to it because it again just draws the same distinction. It does that citing the Sir Jack Jacob article effectively with approval. The one restriction that I mentioned, and this is where Lord Dyson potentially comes into play, and we submit this is of no assistance really in this case, is that in Al Rawi, Lord Dyson made the point, unsurprisingly, and again I'll give you the reference, I don't think I need to go to it because I suspect it's uncontentious. It's tab 26, page 758, paragraph 22 of Al Rawi, that you can't use these inherent powers, whatever they are, to deny fundamental common law rights. And that goes to the point I made, I think, in a question in response to a question from my Lady Justice Laing, about why do we need procedure, what's the relevance essentially of Section 5, and in our submission, Section 5 is particularly necessary in the SIAC context because ultimately what is needed in SIAC is the power to depart from a fairly fundamental right. So what we submit in summary, you can draw from that case law, is that although SIAC is not of unlimited jurisdiction, it has inherent powers. Indeed, those powers are presumed to exist unless they're expressly excluded. Those powers enable it to determine practice and procedure, save to the extent they interfere with fundamental rights. And certainly we would submit, consistent with the authorities, and this provides, if you like, a basis for the West Ham Union case and the divisional court cases. Costs essentially certainly don't interfere with fundamental rights. They potentially promote fundamental rights by enabling a party to litigate, and in our submission they are matters of procedure, and that's the basis essentially upon which the West Ham Union approach derives. The 2 articles I've made reference to are at tabs 59 and 60 of Volume 2. The first is one that's been cited a number of authorities, including, again, by Lord Dyson in Al-Rawi, which is an article by Sir Jack Jacob entitled Inherent Jurisdiction of the Court. It's from 1970. One 442. He notes that inherent powers, inherent jurisdiction, essentially includes the power to control and regulate process and proceedings. This is at the bottom of 442 under the heading regulating process. Indicates in relation to that it is difficult to set limits and reaches the conclusion at 461 by the second hole punch that the inherent jurisdiction can be described as a reserve fund of powers.
Sorry, which page?
461 is the conclusion he reaches.
Sorry, am I going...
We were on page 33 of
The internal page.
Oh, sorry, internal. Sorry, I was using that. You should have a page number of
But 461, I've got 1443. It doesn't... Does it go up to 1461?
Yes, it does.
Oh,
Yes,
1461, sorry.
Sorry, yes, sorry.
Very end, yeah, okay.
Yes. Sorry, it's page 51 of the internal pagination.
So which is the passage you wanted to refer us to?
It's
The
by
one
the
that's
second
cited.
hole punch. In this light, the inherent
okay.
jurisdiction may be... And that may be described as a broad approach to inherent powers, one that obviously is helpful from our point of view, because ultimately we would submit costs are potentially required to do justice. The narrow approach is perhaps set out in the article that follows, the next tab, the article of Professor Dockeray, Inherent Jurisdiction to Regulate Civil Proceedings.
Neither of these articles consider costs generally, do they?
No, this one does.
Oh, does it?
It does specifically deal with cost.
Yes, okay.
And on rereading it, because his approach effectively is to say, well, you shouldn't look at a single set of powers. But what he does note, this is where he starts at 1464 by looking at sort of the origin of the phrase inherent jurisdiction. And it's by the top hole punch in my version. There's a sentence that starts, the phrase seems to have been in regular use before 1875, only in the law of contempt of court. It began to be used regularly in relation to procedural powers, costs, and control of solicitors about 1880. This is explored in more detail below. He then goes on to deal with. Now, I, on rereading it several times, have struggled to find any express reference to cost further on. But that's an important starting point in our submission, because what he disagrees ultimately with the Jacob approach of saying, well, this is sort of a very broad, unlimited reserve of powers. What he concludes essentially is that, and one sees this at 1471, his sort of ultimate conclusion is probably about 8 lines from the end. Finally, on the third point, and partly for the above reasons, it is not clear whether there really is a single inherent jurisdiction at all, as distinct from a collection of inherent powers. And so he clearly fundamentally disagrees with the Jacob approach, which is there's a sort of broad jurisdiction to do justice between the parties. In that passage in particular, he seems to be saying, look at the circumstances in which inherent powers have been identified, but that is in a context where he identifies, and we would say, although he doesn't appear to cite any authority for the 1875 point, it would seem to be consistent with West Ham Union, it would seem to be consistent with potentially what was being said in the divisional court. The category of cases he identifies as being ones where there is this power include costs. And so on
only in that single word, if you identify.
Only in the single word, but it's an important starting point in some sense. I mean, yes, it is a single word, but it's it is in one sense the context in which he then goes on to say there's not some broad power, it's a narrower power. Now, I'm not sure, I would certainly submit it to the extent I need it, given what has generally been said about broad powers, that conclusion isn't necessarily correct, but in one sense I don't need that because of the approach he adopts.
Can I just ask you his formulation, which is they're residual, but they may be required to give way to statutes and sometimes to statutory rules.
Yes.
Going back to where you're no doubt going to take us to section 5.2a, that has the tribunal rules powers given to SIAC.
Yes.
I mean, is that not giving way, therefore, to the statutory rules saying, well, okay, fine, you might have had this inherent power as to costs, but because there is this express provision in 5.2a, it's given way?
Well, that in one sense goes back to the point that I was making about how do inherent powers operate, particularly in relation to a superior court of record. I accept, and it goes back also to what I'm about to say about the 2007 Act, I accept that if, for example, the SIAC rules said that SIAC can only exercise its powers in exceptional circumstances to award costs, for example, it wouldn't be open to me to come along and say, well, the rules say that, but there is a sort of underlying inherent power, because then the power.
It needn't be as specific as that. What if it said the inherent power to award costs may only be exercised in accordance with rules that will be made, or with any rules that are made?
Well, sorry, if my lord means section 5, or
yes.
Do you mean, yes? I mean, if section 5 said, I mean, it could be explained as there's no power to award costs, then it clearly would be open to Parliament to step in and say.
Well, that's easy, but there could be a halfway house there, which effectively says the power to award costs, assuming on your submissions to date that there is such a power inherently, the inherent power to award costs shall only be exercised in accordance with any rules that may be made by Secretary of State. So that basically excludes the power, the inherent power, except to the extent that rules are made. And where I'm coming to is, isn't that effectively what 5.2a does do, though it's not expressed in that way?
Well, my lord, but I accept, because I think I've been consistent, hopefully, in relation to this, that if there's an express power to exclude, if there's an express statutory provision that excludes the award of costs, then that clearly overrides any inherent powers. So if there was a provision which effectively said you could, and I'm paraphrasing, I think the provision the law was putting to me, but if there's a provision that effectively says you can only award costs if the rules provide for the award of costs, then that expressly excludes the jurisdiction. The difference here is that there is a general provision that says you can make rules. First question that potentially throws up, and this goes on to the 2007 Act, that is whether, because it links to the 2007 Act, whether that power is simply about the exercise of a discretion to award costs, or whether that power is necessary to enable an award of cost. And our position is that when you link it back to the 2007 Act, the power is only one that effectively governs how a discretion should be exercised. So for that reason, it doesn't exclude an award of costs.
Sorry to interrupt, just on that particular point, how does that work with the FTT?
Well, with the FTT, because there is, with the FTT, on our analysis, the legislation, I'm just trying to remember exactly how the legislation works, but with the FTT, again, our analysis, I think, would be that the statute provides for a discretion to award costs. It doesn't require rules to be made. And that then links back to, in one sense, a fundamental point that's been made in the aid and shipping case, which is there's a distinction potentially between a statutory provision that enables what would otherwise be a broad discretion to be regulated, and a provision which effectively cuts out an award of costs. And so our submission is that Section 5 doesn't in any way prevent an award of costs. So it's not an express restriction on the power to award costs. It's not necessary implication. What it does is enable the regulation of any power to award costs, assuming there is a power to award costs.
But how can an implied power to award costs coexist with the power of the Lord Chancellor to make rules regulating procedure in SIAC, including rules about costs? I'm really struggling to understand.
Because, and it may be worth looking at the aid and shipping case, because in our submission, and it goes back to what we say about the nature of inherent powers. Our position remains that in relation to inherent powers, they are exercisable by SIAC, and it's for SIAC to decide how to exercise them, unless there are rules, and the rules essentially are coexist because they enable the exercise of power that otherwise would be broad to be restricted by the making of rules. My lady, if I can just go to, because it may help, I've referred to it a moment ago, and how we would submit this potentially operates, an example of this. Obviously, there's been reference made by both parties to Section 51 of the Senior Courts Act, which is it's in Volume 2, tab 41, page 1215.
So sorry, I didn't pick up your reference.
Sorry, no. It's tab 41, volume 2, page 1215. And that, I'm sure you've already seen the language in pre-reading. that is a provision which governs costs. I use that language deliberately because of the dispute about what it does. But on the face of it, in our submission, it is primarily concerned by talking about costs being at the discretion of the court, with making it clear that a jurisdiction to award costs is broad. If it were primarily there to ensure that there was a jurisdiction, one might expect language such as the High Court, for example, has the power to award costs. But that's not the language used on the face of it. Now that, it may be worth keeping that open, was first considered at House of Lords level in the aid and shipping case, which is in volume 1, tab 13. And the relevant page is page 431.
(421).
431.
Thank you.
Just to put it in context, because this may be relevant, the issue in that case was, and this is why I've gone to 431, one sees just by letter G that the issue in that case was essentially whether or not Section 51 authorised cost orders against non-parties.
What's the passage that you want to refer to?
The passage I need to take you to is at 434 by letter E.
Can we just now read this?
Yeah.
Yeah, so what you're saying is the inherent jurisdiction is the equivalent of Section 51(1), and just as the discretion granted by Section 51(1) can, as Lord Groff explains, be regulated by rules of court, so the inherent jurisdiction as to costs can be regulated by rules of court, but that's all that Section 52A is doing.
Yes, but I'd go slightly further. I'd go slightly further. What I'd also say is that it also indicates, in one sense, clearly issues like inherent jurisdiction weren't before the court in aid and shipping. But what it's clearly indicating is that the purpose behind Section 51, in one sense, or at least a purpose behind Section 51, is to make it clear that the starting point for then the subsequent exercise of the rulemaking power is broad discretion. So it's giving the rulemaking body a broad power, and that's why Section 51 is there, which is consistent with our submission, which is an answer to a sort of implicit submission made against us. Why do you need Section 51? The reason Section 51 exists is to make it clear that the starting point is a broad discretion.
Yes, the power to make rules of court doesn't appear in 51(1. That's simply a cross-reference to or acknowledgement of a provision that we find somewhere else in the Act.
Yes. Yeah. Just in passing, I don't think I need to take you to it. The Section 51 has been considered again at least once more at sort of the highest level. This time by the Supreme Court in CPRE Kent, which is at tab 36, the relevant passage, page 1056, which paragraph 14 refers to section 51, but again, it's not dealing with inherent powers. It started from a position where effectively the argument between the parties was derived from section 51. It didn't look at what the inherent issue was. So our position in relation to section 51 is that all section 51 does is, or the primary thing it does, is indicate that the starting point is a broad discretion. It's about how costs should be awarded. It isn't phrased in terms that indicate effectively that the starting point was that Parliament believed a need for a power to be derived from statute. Because if it had been if that had been the approach, one might have thought that Parliament would have said the High Court has a power to award costs, but that's not how it's expressed. The 2007 Act, going back to volume 2, is at tab 50, and the relevant passage starts at...
Sorry, which tab did you say?
Tab 50.
Thank you.
And the relevant passage starts at 1264. And there's also the additional provisions that have been included. Section 3, which is at 1264, is the provision that draws the distinction between the first tier tribunal and the upper tribunal, making it clear that the upper tribunal is a superior court of record. Section 29, which is at 1265, is a provision which is very similar to the Senior Courts Act provision we've just been looking at, section 51. Again, making it clear effectively that the tribunal has a broad discretion. Again, on the face of it, not using language one might expect if that were necessary. It not saying in express terms, essentially, that there is a power to award costs, rather assuming that there is, but saying how that power should be exercised. But then subsection 3, making it clear, consistent with the submissions we've made, which is that and consistent in one sense with the approach in aid and shipping, which is that discretion is subject to the tribunal procedure rules. So making it clear effectively that the rules can constrain that broad discretion. And that goes back to the point I made before about what the rules can do. On the face of it, what the rules are concerned with is governing what would otherwise be a broad discretion. And that's why, going back to the marker I put down before about what the tribunal procedure rules do, or can do, in our submission, the tribunal procedure rules can limit the discretion to award costs. Indeed, that's obviously what they do. If they didn't exist, one way of looking at this is that the tribunal would have a broad discretionary power, both the upper tribunal and the first tier tribunal.
Have we been given, or is this one of the things my lady asked for, the actual provision of the TCEA giving the rule-making power?
Yes, we have. It's
Where
section
is it?
22, but it
Where
was
is it,
it,
sorry?
it was one of the papers my lady asked for.
Yes. And stupidly, I didn't print them out, so
I think I can probably. Have you got a spare copy? Yeah, we'll give you a spare copy.
that would be very helpful.
That will give them all. I'll hand up all the statutory provisions my lady asked for, so that we don't have to repeat. If I can. Sorry.
Do we have a?
Thank you.
Thank you.
Sorry, they were all for Lord Justice Underhill. Sorry, I assumed.
Oh, sorry, they're all for me, apparently.
Sorry, I assumed only Lord Justice Underhill had an issue. We have. I have more copies.
The others are probably more organised.
I'm
haven't
not.
printed.
Okay, we have another copy. Sorry.
I meant to print them out and forgot.
Sorry.
So that's very
Sorry.
helpful. Thank you.
I'd assumed silence meant.
You don't need them.
No, well, I was
No,
misunderstanding what was
Yes.
going on. Thank you so much.
Section 20, my Lord, in answer to my Lord's question, Section 22 is the rule-making power.
Yeah.
Interestingly, describing fundamentally the rules to govern practice and procedure, perhaps supporting the point I made before about cost being ultimately a matter of procedure. Nothing in Section 22 expressly deals with cost, but as my lady's question foreshadowed, if one goes to Schedule 5, and in particular paragraph 12, that enables rules to be made regulating matters relating to costs. So, which is interesting language as well, potentially, on the basis that that language of regulation suggests that what the rules can do is not bestow a power to award costs. What they can do is determine the way in which the power is exercised.
Well, of course not, because of Section 29.
Absolutely, Melissa. But that goes back to the point I was making about what's the effect of Section 5 of the SIAC Act.
Are we going there now? I mean, if you're making the point, this is a crucial point. If you're making the point in passing, so be it. Are we now going to the Section 5?
We can certainly go back to Section 5, yes. Then just to see it. Sorry, I've Section 5 is at
Well, in its current form, it's at 1255.
yes, 1255, exactly, my Lord. And so the provision says rules under this section may in particular do anything which may be done by tribunal procedure rules. Which may be done. So no dispute, to be clear about where there isn't any dispute, that the tribunal, the SIAC rules could, for example, say any power to award costs can only be exercised if one of the parties behaves unreasonably. Because there's no dispute that the tribunal procedure rules could, and indeed do, regulate the award of costs in that way. What the tribunal rules can't do, because quite clearly, see Section 29 in particular, the power to award costs is either provided for by Section 29 or recognised as being an inherent power that is regulated by Section 29. What they can't do is give a power to award costs where one doesn't exist, because in fact there is no situation where a power to award costs doesn't exist.
Well, we're looking at 52A for obvious reasons, but
Yeah.
in fact we have got, that's actually merely a gloss on the powers given in 5.1, may in particular do anything, which So I think it may be helpful to see exactly which of 5.1 applies. The Lord Chancellor may make rules, and then it's B, for prescribing the practice and procedure to be followed to appeals under section 2B. Then I don't think it's 1C, because 1C doesn't deal with practice and procedure. It talks about other matters, preliminary or incidental. Unless you say costs aren't practice and procedure but are incidental. I don't think it's...
No, our case is practice and procedure, yes.
Yeah.
But, but this, in one sense, goes back to what's the scope of the inherent power, and also what is the what's the relevance, if you like, of the presumption in house breeze. The 5.1b, particularly when read with 5.2a, would potentially allow SIAC to say, as I've already accepted, for example, so the SIAC rules to say, as I've already accepted, if there is a power, any power to award costs can only be exercised in unreasonable circumstances. So there's no doubt, because of 5.2a, but also 5.1b, that you could issue a rule saying, as I say, the power to award costs can only be exercised in unreasonable circumstances. But what 5.1b doesn't do, and we would submit 5.2a doesn't do, because it's not concerned with the power to award, it's concerned with the discretion, is it doesn't exclude any powers that may already exist.
Can I ask you a question about the history of Section 5? Because when Section 5 was originally enacted, SIAC wasn't described as a superior court of record as it now is.
Yes.
So did SIAC have a power to award costs before it was described as a superior court of record?
Probably is the answer to that, but I'm not. In one sense, I'm not sure.
Well, I'm just testing your argument.
Well, the reason why I say probably, and the reason why I was going to say I'm not sure it assists, is that in one sense the starting point is different, because what I would accept, and this is where and I may have, in answering the question I think from my Lord Justice Dingemans, perhaps slightly misdescribed what we would say the approach to the first tier tribunal was. If one didn't have the provision as to superior court of record, in our submission, the difference would be, the material difference in this context would be that one would then need to look at what fundamentally SIAC was being required to determine. That would still be governed by provisions like Section 2. One would then need to look at what powers would be necessary to do justice to the parties, and we would say costs can be a power that are necessary, which is why there probably was still inherent power. But you wouldn't effectively start with a presumption. That would be the difference, effectively.
Sorry, you wouldn't start with the presumption that SIAC had an inherent power to
Yes.
make a cost order?
Yes.
I see.
Sorry, just remind me, when was Section 1.3 introduced?
I think it was...
2001?
Yes.
Yes, I think it was 2001.
I think it's 1228.
Yes, I was just looking back. Yes, it's 1226 is the provision up until the 13th of December 2001, and 1228 is the provision from 14th of December 2001.
So, yes, I see. I have misled myself for a moment. Insofar as your case depends on 5.1b, that precedes SIAC being a court of record.
Yes.
insofar as it depends on, well, insofar as you have to grapple with 5.2a, by the time 5.2a came in, which it first did in 2000 and sorry, I wrote all this down and didn't bring it in.
I think it came in with the Nationality Immigration Asylum
Came
Act
in 2002. It was already a superior court of record by then.
Yes.
And that's so at the point where costs are first mentioned, albeit indirectly, it was a superior court of record.
Yes.
But the reason why you say ultimately this doesn't matter is really goes back to the debate you had both with me and my lord, that you would say that a power to award costs was part of the inherent jurisdiction of SIAC, irrespective of whether it was a superior court of record. It's just that the argument becomes stronger once it is a superior court of record.
Yes. My lords and my lady, the other provision dealing with costs essentially in a superior court of record that's been cited by the parties and drawn and parties of is the which is at tab 43 of volume 2 is the Employment Tribunals Act. Section 20 at 1222 makes it clear that the Employment Appeal Tribunal is a superior court of record.
Can I just pause there? Has there been any learning on why that was introduced? Which I suspect, well, the first question is the provision that it's a superior court of record go right back to 1975, or indeed 1971, which would be the National Industrial Relations Court? Someone should look into that.
Yes. Yes,
as a matter of history, it's pretty clear why it was introduced into the SIAC Act, I think. But the reasoning may not have been the same in 1971. Maybe they were concerned about judicial review then as well. I say 1971. The Employment Appeal Tribunal actually started in 1975, I think.
Right.
The history for that is that there was a National Industrial Relations Court which lasted from 71 to 74. There was then a brief hiatus when basic employment matters were dealt with in the High Court. And then in 1975, the Employment Appeal Tribunal was founded by what was then, I think, testing my memory, it was the 1975 Act. I can't remember what it was called. I think it would just be worth, over lunch, someone checking back the history.
We'll do our best. I mean, I do note that firstly, I note that the 1996 Act, the annotated version in the bundle, doesn't suggest any that there was any amendment of the 1996 Act to add superior court of record. It is. I mean,
Now, I think it's pretty likely, but we won't know till we look, that it's always been a superior court of record.
Yes.
Yeah, I had a little bit to say about it in Para 6 with my observations on permission, but I only went back to 1978. So it was a superior court of record when the EPCA was enacted, whether it was or not.
Yes, well, that was only a consolidation act, so it must have been since at least 1975. And then perhaps it doesn't really matter about the National Industrial Relations Court, but it might be worth looking just for completeness.
But I mean, clearly, it is used in circumstance. I mean, another example of a circumstance where it's clearly not used to isolate from judicial review, because it would be a nonsense if it was being used for that purpose, is the Supreme Court. As I've indicated, the statute establishing, I think it's the Constitutional Reform Act, says that the Supreme Court is the superior court of record.
And I believe, in fact, my lady may remember this better than me, that there have been very rare cases where the decision of the EAT have been judicially reviewed, obviously normally it's entirely wrong on
Yep.
general principles. That it's a well, I suppose it's rather like cart, isn't it?
Yes, well, exactly. I mean, of course, that's the distinction, or the three categories, or the three potential distinctions that Lord Justice Laws draws attention to. I think it was the second.
Yes.
Immunity
Well,
from judicial review.
let's if you just factually
Yes.
get the answer on that, and I'm grateful to my lady.
Thank you.
She got there first. Right, but what were the points you were going to make on the assumption?
The point I was going to make was, if you then go to section 34, which is the rule-making provision, in one sense, consistent, well, what that says, obviously, which is slightly differently worded, is it does refer to the rules having potentially including provision for the award of costs. That, in one sense, I accept that wording is perhaps less clear as to whether there is an assumption that there is already a power to award costs and it's about regulation, or whether, by implication, it is saying effectively that if there were no rule, costs couldn't be awarded. All I would say is, in one sense, the extent to which that particular provision suggests that effectively rules are required to award costs cannot provide some general rule that the starting point is that effectively you need a statutory provision.
But I think you're being appropriately not giving away more than you need. I'm bound to say that that power seems to be proceed on the basis that there would not otherwise be a power to provide.
Yes.
And your answer to that is, well, that doesn't mean there's a general rule that that's never the case in any tribunal.
Yes.
But it does suggest the situation is rather messier. It's not quite clear why the Employment Appeal Tribunal should not have an inherent power, not be regarded as having an inherent power, when SIAC should.
Well, but in one sense, one of the difficulties of trying to work the answer out to that is knowing what the position was if there hadn't been that section 34. I mean, if you hadn't had section 34,
you would have been arguing. Sorry to interrupt your train of thought. You would have been arguing in an analogous case. I know there is no express provision to award costs.
Yes.
But it's a superior court of record. It's the award of costs is inherent. The power to award costs is inherent to the doing of justice in any inter partes jurisdiction. So it doesn't matter that there isn't an express power. There's an inherent power.
Yes.
And the draftsman didn't think that was the case.
Well, except what the drafts. If you contrast this with, say, the aid and shipping approach, obviously one of the features of the Employment Appeal Tribunal has always been that it is intended to be low-cost litigation. So what the draftsman may have been seeking to do here is, if you like, adopt a different starting point to that in aid and shipping, and say the starting point in this new tribunal is costs aren't awarded unless someone's decided they're a good idea they should be.
It's certain, on any view, this predates the 1981 Act.
Yes.
Can't I remember what was under the Supreme Court Act, as it was then called. I can't remember was there an equivalent to Section 51?
Well, by implication, because of ex parte Osmond, I think ex parte Osmond deals with that history. And
I don't know.
Because ex parte Osmond, the reason they were going, they were looking, if you remember, at the divisional court practice was because
the reference to practice
before 19,
which rather suggests there wasn't any predecessor to Section 51.
Yes, it certainly isn't a consolidation. That's why I was referring to ex parte Osmond.
Yeah.
But my lord, all I'm suggesting is that if you, in one sense, what this legislation may suggest is that when a tribunal is established, there are at least two approaches to costs, or when one is to indicate effectively that any power, and I'm not going to deal with the source of the power because that's obviously controversial, but trying to put it in neutral terms, any power that may exist to award costs is broad unless cut down by rules. The other is to indicate the opposite, effectively, and that's all in one sense what the 1996 Act may be doing because of the.
When you say the opposite, what do you mean?
Well, the opposite being that
no power unless conferred.
No power unless the rules grant it. Yes, but that doesn't tell you very much about what the situation would have been had there not been that provision. Because we accept. I mean, we accept. Obviously, if the SIAC Act said you can't get costs in SIAC, there'd be no possible way that I would be arguing this case.
Well, I think, speaking for myself, it gives a clear indication of what the draftsman thought, but that draftsman may have been wrong.
But it also it gives the, well, I'd put it slightly differently, my lord, with respect, which is it gives a clear indication of what the draftsman was trying to achieve in the Employment Appeal Tribunal, which is he was trying to achieve a starting point of no order for costs unless a costs order. But whether
unless there's a rule.
Unless there's a rule, sorry, unless there's a rule.
While we're looking specifically at the appeal tribunal, because that's a superior court of record, have we been given the equivalent provisions for the employment tribunal, or indeed industrial tribunal, if we're going to go back into history, which also has a power?
I don't think we have, partly because I think the focus had been, because they were more directly relevant in one sense, on the Senior Courts Act and the 2007 Act, and then obviously when they raised this.
It's clearer to me than it was at first that your case isn't necessarily pinned on Superior Court of Record.
No.
Although it helps you.
Yeah.
I think, just like my Lord's questions about the FTT, it would be quite interesting to see how the draftsman dealt with the IT.
I'm sure we can
find more work over lunch.
Well, yes, it may take slightly longer than lunch because we're less familiar with that jurisdiction, but I'm sure we can find it over soon.
Yes, I agree. You would need to look at, well, it would be the same act. It's the Employment Tribunals Act.
Yeah.
Because that covers both the ET and the EAT. We'd let you off going back into history for the time being.
And it would have been the Employment Protection Consolidation Act.
Before that, it was the 1978 Act, which my lady referred in her order, and that itself was consolidating earlier acts.
Right. But we'll do the best we can over lunch.
And just talking about lunch,
I think
I had thought, probably, I know the person going first reasonably takes a bit longer, that you would be certainly have finished everything except Article 14 before lunch. And in fact, Article 14 is quite a big issue. So how much longer are you going to be on
I think that timetable is not unrealistic because I basically have now covered the big issue, which in one sense is there the power.
Yeah.
The two other issues are not insignificant, obviously, from my point of view, but they can be dealt with, I think, much quicker.
Yes, okay. Okay, I'm going to put a line on there. That's all on whether there's a power. So you're now at the moment coming, if there is, should it have been exercised?
Yes. I mean, which raises two questions. The first is, what should be the approach, effectively? Was it right to import the first-tier tribunal and the first-tier tribunal rules of unreasonable conduct?
Yes, right.
Then the second question, which is, if it was right, was there unreasonableness in this case?
But if SIAC, if the first step of your argument is right, and SIAC has got a broad general power about costs, why can't it say we're going to exercise this power in this particular way, i.e. only when there's been unreasonable conduct?
Well, because in our submission, the starting point then is that this is a broad power. It hasn't been restricted. It could be restricted under the SIAC rules. It hasn't been restricted. Unreasonableness in the first tier tribunal reflects the features potentially of first tier tribunal litigation. SIAC is very different litigation.
Sorry, I focused so much on the big point. I haven't really understood just what the structure of this point is. Forgive me for not having picked this up. Are you? Is it your case? Was it your case below that you should have your costs only on the basis of unreasonableness?
No.
No, because you won.
It was your case that it's at large, and you should certainly, because you'd won.
Yes.
But you had a fallback case on unreasonableness.
The argument against us was that the unreasonableness test applied, and so we had a fallback position. Yes.
Yes. Thank you. Right.
Yeah. Yes.
Yeah, okay. And just lastly, I suppose it depends on what basis you win on this. If you do win,
yes,
it might be said that the right course for us was to send it back to SIAC to decide what to do, having regard to the. Now we'd established there was a jurisdiction and what the correct test was.
Well, yes, my lord. Yes.
Isn't that actually what we ought to do?
I don't think we would have any issue with that. No. No, I don't think.
Well, we'll think about that. I may be wrong, but there's obviously some advantage in having matters dealt with once and for all here. On the whole, where we're dealing with the discretion that wasn't exercised below, certainly in the employment jurisdiction, we tend to send it back and say, now we've told you what you...
I mean, the decision did deal with the position if there was a power, but only to make a cost order if there had been unreasonable conduct. So SIAC did consider
Yes, I see.
whether or not there had been unreasonable conduct.
Yes, I see.
There hadn't.
Well, the reason why, and one of the reasons why I think I was not very resistant to the idea of remission is that in terms of the reasons for adopting an unreasonableness test, perhaps unsurprisingly, given that the primary conclusion clearly was there was no power. I mean, one could say, and I say this slightly sort of lightly on the basis that I'm not being very critical, given the first point, that SIAC doesn't brilliantly engage with why the unreasonableness test is necessarily imported, and so it might be if this court were to conclude that there is jurisdiction, the starting point is it's because it's unregulated, it's potentially a broad jurisdiction. It might be of assistance for SIAC as if you like, the first instance court with specialist knowledge to think about what factors were potentially relevant.
Okay. Well, anyway, sorry. Forgive me for not having quite bottomed that out. But now
no, it's probably
go back to your submissions.
But my lord, I go back to if we're right on our primary argument, the issue the position one gets to then is that there is an inherent power to award costs, and that is unregulated on the face of it. The SIAC rules, I think everyone's agreed, say nothing about the approach, in contrast to the first tier tribunal. First tier tribunal is bound by those rules, whatever it thinks of them, effectively.
As is the upper tribunal.
As is the upper tribunal, yes. The question then arises in our submission is whether those rules should be applied in a jurisdiction, and ultimately this is a matter of the court, effectively, because it's practice. We cite Gurley for that effect, should be applied in circumstances where inevitably the nature of SIAC litigation is different. It is an exceptional jurisdiction. It's one where For example, to state the obvious, the individual who brings an appeal, in this case, is in a much worse position to assess the merits of what they're arguing. As a result, they're at greater risk, effectively, of losing for reasons they don't necessarily understand. There is greater complexity. I mean, SIAC in this case noted how, because of the issues that arose in relation to foreign nationality law, the appeal had taken a number of days, 2 experts being cross-examined at length.
C7's case was listed with 2 other cases, wasn't it?
Yes. But I think it's fair to say that probably may have had some impact on the length, on the basis that C7 was represented by a different team to C3 and C4, and C3 and C4 had 1 or 2 discrete issues that didn't arise in C7, but the bulk of the hearing was concerned with the expert evidence from both.
That required no matters of national security because it was a preliminary issue on Bangladesh law, wasn't it?
Well, in fact, the Secretary of State sought to rely on a national security matter, but SIAC concluded it didn't assist it with determining the issue. So there was a short period of closed.
Yes, we haven't seen that, but we see from the open judgment, they say that their judgment is very short.
No, absolutely.
Which suggests that they thought it was pointless.
But I mean, perhaps, I mean, maybe I'm implying more into my Lord's question than there was. In one sense, it is, while it's true that the expert material that this ultimately was determined on the basis of was available to both parties, and so both parties would have been able to assess that, take account of that when assessing the merits of their case. From the appellant's point of view, there was a complication that there was something else he didn't know about, which may or may not have been relevant. I mean, the Secretary of State was clearly arguing it was relevant. SIAC ultimately concluded it wasn't relevant, but he had no way of knowing that. And indeed, SIAC, there was a sort of challenge to whether, as a matter of principle, closed material could be relevant, and SIAC rejected the argument that it couldn't be relevant as a matter of principle. And of course, when looking at the overall merits, although he won on national security grounds, anyone assessing the merits is probably going to look at both aspects, because they're going to want to consider what their overall chances of winning are. And so both those factors, and obviously one's looking here at in any event, at the approach that should be adopted as a matter of principle. And all I'm saying is that in one sense, in looking at the principled approach, these are all reasons why there is good reason to believe the FTT approach is not necessarily correct. In the FTT, there are fundamental, in one sense, there are fundamental differences between the way the FTT operates and SIAC. The FTT is very much like a conventional court. SIAC isn't. Another point I think we've made in our skeleton argument, but for example, the FTT has an overriding objective, broadly the same as every other overriding objective. SIAC doesn't.
Well, it's got Rule 4, which is
it's got Rule 4.
different.
Exactly, but that's Rule 4 is an unusual provision which is intended to address the particular problems resulting from closed procedure.
Exactly.
I always thought the overriding objective stated what was the overriding objective of courts anyway, and it was just a sort of declaratory.
Well,
whether it was in the CPR or in the slightly different iterations you find in all the different tribunal rules.
But you see, in my submission, and this was the exchange I just had with my lady, what Rule 4 does is it makes it clear that the first rule, effectively, of SIAC is that material cannot be described, absolute bar, cannot be disclosed if that's contrary to various provisions. What it then does is seek to balance that out in various other ways, including, in particular, the obligation to be fully informed.
Yeah.
So there is, that's what and all of that, what that demonstrates in one sense, the reason I drew attention to this is something that we've put in our skeleton argument, which is that one of the, I mean, this court has made it clear that one of the basic principles that SIAC has to operate under is that because there is this starting point, which is contrary to normal requirements of fairness, there's a particular concern to balance that unfairness and to ensure that there isn't further unfairness. And the point we make about discretion, and this is in one sense the summary, the heart of it, is in this context, someone, and I accept legal aid was in place in this case, but wouldn't necessarily be the case. Someone is potentially deprived of their citizenship on grounds they don't get told. They potentially then have to expend significant sums of money because of the complexity of the matter. As I say, not knowing how strong their case is or how weak their case is. And ultimately, if they win, it is surprising that they don't get back their costs.
But putting the boot on the other foot, as it were, I mean, would it be tolerable for people in that situation who lose their appeal to be stung with costs?
Well, 2 points I'd make about that, but they're related points. Firstly, I don't necessarily accept, if SIAC is developing a practice, that there should be even-handedness between the Secretary of State and the appellant. The Secretary of State has inherent advantages that the appellant doesn't have, because the Secretary of State has the full picture. And
sorry, I misunderstood. I thought your argument was SIAC should exercise its power so as to provide for cost to follow the event, but that's not.
In the event of an appellant winning, I should have probably qualified.
Yes, I see.
Yeah.
To follow only one event then.
Yes.
So heads I win, tails you lose, sort of
Well,
approach because of the inherent unfairness.
I'm glad I asked that question because I hadn't
Sorry,
appreciated
that's
all
probably
heads.
my.
Heads I win to the extent that I ordinarily win.
Yeah.
Heads, not necessarily you lose, but a different approach.
A different approach.
Yeah.
To some extent, the positions are balanced to recognise the fact that one side knows the full merits of the
So
case.
would the appellant ever, on your case, would the appellant ever be ordered to pay costs?
Well, potentially, yes. I mean,
But how? I mean, in
Well,
what circumstances?
suppose, well, a good example potentially is the nationality issue. Suppose, unlike this case, then the nationality issue had been totally and open, and it was clear that an appellant was relying on, well, I was going to say relying on hopeless evidence, but maybe not. Maybe.
Well, is that? Sorry, I shouldn't interrupt you.
Yeah.
But if the issue was one of fact, suppose it was where were you born? Well, if people only know, strictly speaking, you don't know where you're born. You rely on what you're told. But nevertheless, you're likely to know more about it than anyone else. And there's no doubt what the foreign law is. It all depends on where you're born. And you put forward a false case that you were born in Mauritania, and you weren't, and you knew you weren't. Well, then you certainly have to pay your costs.
Yes, I mean, the point, absolutely, my lord, and it was consistent, I think, with the point I was about to make, which was broadly, if all the material is open, there's no reason why you shouldn't pay your costs effectively, and that can be the case. Obviously, if all the material in relation to an issue is open and you lose that issue, no obvious reason why you shouldn't pay your costs.
Right. So let's take this in stages. So if all the material is open, costs follow the event. Is that it?
Yes.
On both sides.
Yes.
And if not, then costs don't follow the event.
Costs don't follow the event as far as the Secretary of State is claiming costs are concerned.
So appellant gets costs if appellant wins, but the Secretary of State doesn't.
Yes. Then there's a different approach required, partly because the Secretary of State has a greater advantage. The Secretary of State can't complain, I was not in a good position to assess the merits.
Okay.
But I don't think, I mean, although we may want to do this in order to see how it all works, it's not necessary for your case for us to say what the new principles should be in all circumstances. We should only say what they should be in the present circumstances.
Yes.
Or if we can't even do that, send it back to SIAC.
No, I mean, it's my fault. I was just asking the questions to test how far the argument goes.
Yeah.
Right. Where are we going now?
Finally, and I will deal with this quickly, but I'll do it by reference to our skeleton argument. If unreasonableness applied, our skeleton argument sets out the unusual history of this matter. The key points, really, it's paragraph 60 of our skeleton argument. Firstly, the Secretary of State instructed 5 experts, if my maths is right, before the expert instructed in this case. 3 of those experts, when preparing reports, essentially supported the appellant's argument. 1 was disowned by the Secretary of State, and 1 was rejected by SIAC. The appellant's expert was one of those 5 because the Secretary of State had used the appellant's expert in the Shamima Begum case.
Is it Professor Hock?
Professor Hock, yes, who has been used by both sides at different points in time. And the consequence of the Secretary of State deciding to go for a 6th expert was it placed a significant burden on the appellant, required lengthy argument. Now,
as I understand SIAC's judgment on the nationality issue, SIAC didn't say that the evidence of the 6th expert was utterly hopeless and mad. It was a bit more nuanced than that.
They did suggest that he was adopting an approach which, in one sense, didn't reflect what SIAC needed to consider, which was what was the likely outcome before a Bangladeshi court of this argument. I mean, that's paragraph 80b of SIAC's determination.
I seem to remember the appellant's expert in Begum adopted a similar approach.
But I'm not here to defend.
No, I know.
Don't you have a difficulty on this, Mr. Southey, that if it comes down to this question,
yes,
SIAC, more specifically Mr. Justice Chamberlain, was peculiarly well placed to make this sort of judgment. Of course, it's nevertheless appealable if he was wrong, or if we're allowed to say that it's plainly wrong. But it'll take a lot to persuade us that his assessment of whether there was unreasonable conduct, having heard all the experts and been part of the tribunal, is appealable.
Well, I certainly recognise that if we get to the point where there is jurisdiction, but it is an unreasonableness jurisdiction, there is a burden that I have to overcome. Put it that way. What I would say in relation to it is that what, on the face of it, Mr. Justice Chamberlain appears to do is equate his finding regarding abuse with unreasonableness, and we make the point we do not accept that's necessarily the case. I mean, unreasonableness is a broader concept, and ultimately we would submit it needs to reflect the fact that the Secretary of State in this case had.
But doesn't that just reflect the way in which the Secretary of State's supposedly unreasonable conduct was characterised in that case? Because the argument was it was unreasonable of the Secretary of State to keep on shopping around for experts and to keep using new experts, and as I think you said, 5 different experts. So the nature of the argument was the Secretary of State's been unreasonable because instead of just biting the bullet, she's gone round looking for other experts to support her case.
Well, sorry. Excuse me for a moment.
All I'm suggesting is it may not be fair to characterise this as SIAC just carelessly unreasonable was with abuse of process.
Before SIAC, on the substantive appeal, it is fair to say that it was being argued by the appellant being argued two things effectively. One was, which was the starting point, that the way in which the litigation was being conducted was an abuse. And the second argument was, in the alternative, in any event, following the Diva-Sealam approach, there are things that you shouldn't revisit, effectively.
Well, those are two sides of the same coin, aren't they?
No, in the sense that SIAC accepted it was not an abuse, but went on to conclude that effectively the Diva-Sealam approach applied, and that as a result, the starting point, essentially, that SIAC had to adopt was reflective of previous findings.
Yes.
So that's why I'm saying that they're not two sides of the same
No,
coin.
But what was said to be unreasonable, as I understand it, was that the Secretary of State, instead of, as I say, biting the bullet, had gone on and looked for other experts.
Absolutely. No, that sorry, I'm maybe misunderstanding the question. That's exactly what was being argued, but my point about it is that the response to that, in our submission in paragraph 16, essentially focuses on whether, and it's the sort of second sentence in particular, paragraph 16, page 118, whether there was an abuse of process. And our submission is effectively that unreasonableness is a potentially broader concept, particularly...
No, I understand that.
Well, I think sounds as though you understand one another.
Yeah.
Would that be a convenient
Yes.
moment? The way I put it this morning, I think this is what we'll still do, but I might have a word with my lord, my lady, and you better be prepared for either outcome, was that we would now simply hear from Ms. Giovanetti on
Yes.
these points, and then come to Article 14
Yes.
at the end. Might just revisit whether we'd asked you to deal not with the substance of Article 14, but with the question whether it's open to you at 2 o'clock. But be prepared for either possibility.
Yeah.
And then, Ms. Giovanetti, well, we have to see where we go. We may be in some time difficulties if Article 14 is allowed to be argued, but we'll see about that. If we're not in that situation, you've got plenty of time, I think.
Thank you.
Yes. Thank you.